Welcome back. Attorney Andrew Bethel of Bethel Law, where I teach you about estate planning, finances, real estate, and taxes. And today we're getting into a little bit more California bashing. This time, court fees for probate. I love you, California, but come on. Today's video is sort of a remake, or really an update, to a video we did over 3 years ago about the true cost of probate. Since that video, however, fees associated with probate cases here in California have only gone up, and I'd like to share some real examples from real probate cases so that you can be informed about how much probate really eats into your hard-earned estate, thus leaving less for your family and beneficiaries. So without further ado, all rise, court is in session, hit the like button, subscribe, share the video with family, and let's dive in. Let's briefly set the stage here a bit before we really dive into the numbers and some actual cases. I won't go over every facet of probate in California. That's a discussion for a whole nother video where we'll really get into the weeds as to the procedure of conducting a probate. Right now, I just want to give you a very brief overview of the process so you understand where we're coming from in terms of where the fees arise. I'll be brief, drop your specific questions in the comments below, and stay tuned for that deep dive into probate. Probate, of course, is the disposition of your estate after you pass away due to your estate meeting one of two requirements: there being real estate or there being a total estate value of $184,500. That number is state specific and varies wildly from state to state, and here in California, that number changes every 3 years with inflation. In order to begin a probate, you file a petition with that county's court. You get a hearing date, you publish a notice in the newspaper, and send notices to the heirs of the estate. You then have that first hearing with the judge where they approve your appointment as executor or administrator, depending on whether there's a will or not. If the paperwork checks out, then the judge will approve your appointment, typically on at least one condition: the posting of a bond to make sure the estate is covered just in case you do something stupid or you run off with all the money. The bond coverage typically is tied to what we think the cash value of the estate is, and the bond premium depends on how much that bond needs to cover. The higher the required coverage, the higher the bond premium you have to pay. We'll come back to that. Once you've been approved and the bond is posted, you can get your ticket from the court to begin closing down bank accounts, selling real estate, and dealing with creditors by purchasing certified letters of administration or testamentary from the court. Again, we'll come back to that. At this point, the estate must be open for at least 4 months to allow creditors to crawl out of the woodwork and make a claim on the estate. During this time, you're administering the estate and consolidating assets. If there's real estate that's going to be kept, then the probate referee does what is essentially a drive-by appraisal of the property, which is what becomes the official court value of the property. That probate referee is not an employee of the court, but are required by law, so they need to be paid for their services too, which we'll come back to. Once the assets have been consolidated, the creditors addressed, and real property appraised, we can file a petition for final distribution to close down the case. We get a second hearing with the judge, they approve the distribution, and you write checks for reimbursements, attorney fees, executor or administrator fees, and finally, distribution checks. If there's real property to transfer the heirs, then you need to purchase a certified copy of that approved petition for final distribution from the court, and then record that order with the county recorder's office to transfer title. If you're here, don't take a breath yet. You keep going, you're not done. You still need to close down the case with the court and get that bond canceled. To do that, you need signed acknowledgement forms from everybody who got a check that they received their check, and you need to file that with the court. At this point, there's technically one more hearing, but it's ex parte, meaning no need to show up. The court is just signing off on what was done. Once the court signs off on what was done, you can finally cancel that pesky bond, and now you're all done. Of course, just about everything I said comes with a hefty amount of these, so again, that was just a speed run of an overview of probate. Now, let's talk fees. The first fee we're going to talk about is the big one. It's going to make you wish you'd gone to law school. You're going to hate the California State Legislature just that much more, and you might even come out of this video not liking me as much. So hit the like button now before we get any further. All of this is because attorney fees for California probate cases are fixed, or more precisely, the formula to calculate attorney fees is enshrined by the California Probate Code, specifically Code Section 10810. Which gives us the following formula: 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, 1% of the next 9 million, and 0.5% on the next 15 million, and whatever the court deems reasonable on amounts above $25 million. Also, the attorney can ask for additional compensation for extraordinary services in an amount the court determines as just and reasonable. So, if you ever wanted to play with some numbers to find out what attorney fees would be on a probate, you can go to our website, bethellaw.com/probate calculator, and play around with that. But if you don't have the time, I'll put some example fee breakdowns on screen a little bit later in the video. For now, let's move on to executor and administrator fees because, wouldn't you know it, they get paid a lot too. So let's talk personal representative fees. A personal representative is what the probate code refers to as the executor and administrator because they're more or less the same thing. At least as far as what we're covering today. And wouldn't you look at that? California Probate Code section 10800 gives us the formula for the personal representative fees, and it just so happens to be the exact same formula used to calculate attorney fees. This, along with petty personal reasons, is why you see fights as to who's going to be in charge of mom's probate. Is it going to be the firstborn son or the daughter who stuck around to take care of mom? Sorry, just throwing a wild stereotype out there. In all seriousness, if you thought the attorney fee was high, then be prepared for that amount to double if the personal representative elects to take their entitled compensation. And by the way, they can also ask for additional compensation for extraordinary services rendered to the estate. All right, let's get into the miscellaneous fees that aren't as high as the attorney or personal representative fees, but which will probably still get under your skin as these are the fees that are constantly picking away at you just to make you mad. First up, you can't file anything in court for free, so you're going to have to pay the court over $400 just to get a hearing date to be in front of a judge. Oh yeah, that fee is per hearing to be in front of a judge, which, as you'll recall, is going to happen at least twice, once in the beginning to be appointed executor or administrator, and once at the end to approve the distribution. So all in all, you pay that fee twice. Next, once you have that first hearing date, you have to file a notice in the local newspaper of the first hearing. If you've ever looked at the legal notice section of a newspaper, you'll see a bunch of notices for upcoming probate cases along with fictitious business name notices and whatnot. Of course, the newspaper's not going to do this for free. They need to be paid for their services of publishing the notice multiple times and filing proof of publication with the court prior to that first hearing. And because the publication rates can vary by day of publication and location, then this fee can often vary and does so wildly. I've seen publication fees for a few hundred, and the highest I've seen is $1,300. $1,300. Also, because you can't pick your hearing date and the publication needs to be done leading up to that hearing date, you don't get to plan around the changing daily rate for publication. You're stuck working with what you've been dealt with. Next, if a bond is ordered, and just expect one to be, then the bond company needs to be paid for the coverage. The bond is essentially insurance, and they aren't going to provide the insurance for free since you're going to have to go to a private company for this. The amount of the bond premium owed depends on the amount of the bond needs to cover, and the bond coverage depends on the value of the estate. No flat fees here. Also, here's the kicker. The bond premium is only good for 1 year of coverage. If the estate takes longer than a year to close out, then you're on the hook for another payment of the premium. That's why it's important to get those signed acknowledgments that everyone's received their checks so you can close down the case with the court and get the bond canceled. There is a silver lining in that the bond premium is prorated and refunded for the unused portion when the estate is closed. For year 2 onward. If you finish the probate within a year, congratulations, you're excellent. You don't get any initial bond premium back. But hey, at least you're done. Unfortunately, the fee train doesn't stop here. You see, you need certified copies of court documents to do anything. Close down bank accounts, open an estate account to collect the money, sell the real estate, or transfer real estate to the heirs. And the court is not just going to give that to you for free. You need to purchase the certified letter of administration or testamentary from the court to do any actual administration. And you're going to have to buy multiple copies because you're going to have to give one to escrow, one to each of the banks, and one to the 401k company. Then, if the real estate isn't sold and is instead to be transferred to the heirs, you need to purchase a certified copy of the approved petition for final distribution because that essentially becomes the new deed for the property. Next, you take the certified copy of the approved petition for final distribution and record it with the county recorder where the property is located. What's that? No. County recorders don't record documents for free. You have to pay them a recording fee, and California county recorders charge by the page. $14 for page 1, $3 for each page thereafter. There will probably be a $10 fraud fee, there may be a $2 survey monument fee, and if the property is not a beneficiary's primary residence, then there's going to be a $75 SB2 fee. And if you don't walk into the county recorder's office to record in person, then you have to figure out the fee and just hope you're right. If you forgot about the $2 survey monument fee, or heaven forbid included it when you didn't need it, then the county will send it back and tell you to do it again. By the way, petitions for final distribution are not just one page. They're usually between 5 and 10 pages. Oh, and don't forget the county administrative forms. especially the preliminary change of ownership report or PCOR. They don't charge you to file those forms, but if you don't include the PCOR, then the county charges an extra $10. There are a few other miscellaneous fees that might apply if you have a service file documents for you and provide service or process to the interested parties to the probate, then that company will, of course, charge for their services. However, at least we no longer have to pay to do an appearance by phone in court anymore. You used to have to pay a company $91 per hearing to do so. Since the pandemic, courts now typically provide a way for you to just call in at no additional charge. So, hey, small win there. Before jumping into some messy real-world examples, on screen I have some basic examples of fee calculations for probates in California. Again, go to the link on screen or in the description for your probate fee calculator to get a better understanding of your particular case. All right, enough messing around. Let's look at some actual cases from our office. These are real cases from our office. I haven't made anything up or cherry-picked egregious examples. The only requirement was that the case had to be completely done at the time of filming, and of course, I won't be sharing any private or identifying details. All right, first case here started in August of 2022, closed down December 29th, 2023, or roughly thereabouts. Clients paid $1,500 fee deposit. Superior Court filing $465. Attorney service to file everything $50. Newspaper in order to file the notice for the first hearing $353.88. Court call, ooh, it was $94 at that point. The bond company $231, small bond. Let's see, probate referee, $444. And at the end of it all, the attorney fee on this case was $10,461.39. All right, this next case, we began around March of 2022, and it didn't close down till close to October of 2023. Superior Court charged $480 to file. Newspaper charged $508. The probate referee charged $436.20. The final fee to the Superior Court to close the whole case down, $465. During the process, we did have to purchase 2 copies of certified documents, costing a total of $81. And at the end of the case, the attorney fee was, let's see, $13,774.32. All right, let's grab another case. Ooh, I remember this one. We started around August of 2021, and it didn't finish off until close to the end of 2022. So, our initial filing fees with the court, $480. Newspaper charged $453. We had to purchase 2 certified copies of the letters, $81 total. Later, we had to purchase more certified copies from the court, so $162 more out the window. The big one in this case was the bond. It was a big bond because it was a big probate case, so the bond premium per year, and they paid this twice, was $2,610. Lastly, the fee to close the case with the court, the final filing fee, $465. Which brings us down to the end, the attorney fee, and the executor also took a fee on this one, $24,450, which again means that was paid twice. All right, you've made it to the end. Your pockets might be a little lighter, but you've made it. You're now an expert on what fees to expect if an estate goes to probate in California. But here's where I ask you some questions. Do you think these fees are too much? That's dumb. Of course they are. The real question is, are you going to let your estate be eaten up by expenses, or are you going to properly plan your estate with a living trust to avoid these baked-in fees? Let me know in the comments below. Be sure to like and subscribe for that deep dive in the probate process. Send me any questions or a topic you want me to cover. I'm attorney Andrew Bethel, and I'll see you next time.